Okay, you ready? Good morning. The time is 11:40 on Wednesday, January 15, 2014. I'm Councilmember Tommy Wells, Chairperson of the Committee on the Judiciary and Public Safety. I note that we have the presence of Councilmembers Bowser, Evans, and Che. We have an assembled quorum of the committee. We're here today in room 123 of the John A. Wilson Building at our regularly scheduled meeting time to consider and vote on Bill 20-409, the Marijuana Possession Decriminalization Amendment Act of 2014. On July 10, 2013, I introduced Bill 20-409 along with 7 of my colleagues, Councilmembers Bonds, Che, and Evans, who sit on this committee, and Councilmembers Berry, McDuffie, Grosso, and Graham. 2 additional members, Chairman Mendelson and Councilmember Catania, co-sponsored the legislation. The committee held the first of 2 public hearings on October 23, 2013 in a packed community meeting room at the Anacostia Public Library, where more than 100 people came out, a quarter of them as public witnesses, but all as engaged listeners to participate in the public process. We reconvened the hearing the following day in the council chambers. We received testimony from more than 25 additional public witnesses and advocacy groups, as well as from the government. We heard over and over again about the distressing statistics that surround marijuana arrests. Every year, nearly half of all drug arrests in this country are for simple possession of marijuana. According to the recent reports from the Washington Lawyers Committee and the ACLU, the District of Columbia has a much higher arrest rate per capita than Los Angeles, Miami, or Philadelphia. Although our black and white residents use marijuana at similar rates, our African American residents are 8 times more likely to be arrested for marijuana use than white residents. Nearly 90% of those arrested in our city are African American. The expense and time required to arrest and prosecute people solely for possessing marijuana is a significant drain on the energies of our police and our courts, but these arrests have even a higher cost. The human cost found in devastating effects an arrest has on a person's life. An arrest record impacts a person's ability to keep the job they have or obtain a new one, as well as their ability to find housing and continue their education. We know from decades of the drug war that criminal penalties for possession of small amounts of marijuana does not deter marijuana use. Those who are arrested for smoking marijuana are no more likely to stop than those who are never caught. Criminalization of marijuana does not work. It is clear that the current law must change. It is no longer a question if the law should be changed, but the question of how. I believe the committee print before you today effectively answers that question, and it balances the concerns raised in the hearing with the clear policy goal of ending the disenfranchisement of an enormous segment of our city. Specifically, the committee print decriminalizes the possession or transfer without remuneration of 1 ounce or less of marijuana, making it instead a civil violation subject to a $25 fine and making smoking in public a civil violation subject to a $100 fine. It provides that the police may seize marijuana and paraphernalia visible at the time of the violation. It requires persons stopped for those violations to identify themselves to the officer, and if they refuse or knowingly provide false information, such action is a crime, and that carries an additional penalty. And the print places the adjudication process with the Office of Administrative Hearings, and requires them to send a copy of the notice of violation to the parent or guardian when the individual who receives the notice of violation is under 18 years of age. The committee print also makes a number of conforming amendments to existing law to reflect the change from a criminal violation to a civil one, including provides that a civil violation under this legislation cannot render a person ineligible for public assistance or a driver's license. Clarifies that a positive test for marijuana or a violation under this bill shall not be a violation of the conditions of pretrial release or probation unless the judicial officer expressly prohibits the use or possession of marijuana. Provides that a search warrant shall not be issued solely on the basis of possession of 1 ounce or less of marijuana, and outlines the circumstances that do not constitute reasonable articulable suspicion of a crime. This is an important provision and reflects the judicial reasoning from other states that have decriminalized possession of marijuana. The committee and I have worked closely with the administration and social justice advocates to incorporate the concerns raised at the hearing and the clear need to make critical changes to our drug policy. This is a social justice bill that addresses disproportionate impact. It is a first step in remedying the failed war on drugs, a war that has left individuals, families, and whole communities devastated. I want to note that the draft print before you contains some minor technical changes, and the committee report has been updated to expand briefly the committee reasoning on reasonable articulable suspicion. The committee report also includes a letter that was mistakenly omitted, a letter from a dozen faith leaders who wanted their support for Bill 20-409 on the record. I move the committee print will leave for staff and the General Counsel to make technical and conforming changes. Discussion?
Mr. Wells.
Councilmember Bowser.
And thank you for your hard work. Thank you for your hard work on this bill, and I do have a couple of questions that I just like you to respond to. So, how does the bill address the purchase of marijuana?
The sale of marijuana remains illegal.
Okay, so how do we anticipate people procuring the decriminalized marijuana?
However they possess it or come to possess it, whether they grow it or they purchase it illegally, or dealing marijuana will still be illegal. But however they purchase it, if they are caught with marijuana of an ounce or less, it'll be a civil penalty and not a criminal fine. It's still illegal.
So the seller of the marijuana the selling of marijuana has not been changed.
Nope.
So if a police officer comes upon a transaction where marijuana is being sold, what do you anticipate the charges being? Who would be charged?
The same as they are today, and the person dealing the drug will be the one charged.
And so there would be no charges for the purchaser.
The purchaser will still have the civil violation for possession, which is still against the law, but it's not a criminal violation.
Okay. Does the bill address employment issues? For example, there are some positions in the district government that require drug testing, and marijuana continues to be a substance not permitted. Does this bill address that?
It does address that. There's an exception for government jobs in particular.
What does that mean?
For the government jobs? Like for law enforcement officers, for example.
They may not use the marijuana.
Right, that continues.
Okay. For example, our Department of Parks and Recreation workers, for example, undergo random drug testing. Would they be permitted, if they were marijuana users, would that be permitted?
In the bill, on page 3, states that except as provided in this section, the district shall not request or impose any other form of penalty, sanction, forfeiture, or disqualification for violations of Section 101, provided that this subsection does not apply to district government employers if drug use is specifically prohibited as a condition of employment.
Okay, so in other words, that's saying that prohibition against using marijuana is in place.
That's right.
Okay. Lastly, can you just explain to me about the public smoking? Now, our Attorney General recommended that we outlaw, like we do with alcohol, the public use. So, in your bill, perhaps I'll ask it this way: how does this compare, the language in the bill for public marijuana use, compare with public drinking?
The open container law, as I think you know, is a criminal violation. That is something maybe we should look at, and why we criminalize people for an open container. But what this bill does for smoking marijuana in public, it is a $100 fine. It's illegal, but it's a civil penalty and not a criminal penalty. So it moves away from criminalizing the ingestion of marijuana to making it a civil penalty rather than a criminal penalty.
I know I said finally. This is my last question, I think. For what has been the police chief's position on specifically the public drinking issue or the public marijuana use issue and the public sale of marijuana remaining a criminal penalty, but the possession being a civil penalty?
There has been no public position, and we've dealt, the Office of the Attorney General spoke on behalf of the executive branch, and in fact, I just met with Chief Lanier, and this issue did not come up. It doesn't mean that it, as this bill goes forward, that there may be, they still have time to communicate concerns to the council, but they have not communicated concerns officially in any manner to the committee, other than the committee working with the Office of the Attorney General on the bill, and they support the language at this time.
All right. Well, thank you. Now, those are generally my questions, and I certainly support the goals that are outlined here. I think disparate enforcement of any law is wrong, and disparate enforcement that's racially based is especially, I think, offensive and should be offensive to all of us. I do want to make sure I kind of understand the logic of decriminalization, because for me, I want to know if it's not a crime to possess it, where then are people buying it? And how are we going to deal with that? And certainly we don't want to go back to the days when we had open air drug selling in our city. And so, in fact, the logic of legalization makes a lot more sense to me than decriminalization. And so if we're telling people who live here, people who live in Maryland, people who live in Virginia, it's okay to possess marijuana in the District of Columbia, I don't want the open sale of illegal drugs on any of our corners across the city. So dealing with how people can procure this now decriminalized marijuana, I think, has to be the second step, and certainly in what you're thinking about. And so the public use also, I don't know many of my constituents that are going to be excited about pot smoking in somebody's backyard or in somebody's front porch or on the corner no more than they are about public drinking. And we know that the public drinking laws aren't heavily enforced by the police, and that's a crime. So I wonder what we set up for our police officers to enforce, and I guarantee you, if this becomes an issue, and I don't know that it will. I don't know that people will have congregate in the public to smoke marijuana. Maybe it won't be an issue at all. But I know that we have to give our police the ability to follow up on the constituent concerns that we are going to get about public marijuana use. Thank you.
Thank you, Councilmember Bowser. I do want to assure you and the public that it remains against the law. It's just that the penalty will be a fine, and certainly if you have possession, we'll confiscate it along with whatever paraphernalia is involved. So there will be a fine, confiscation, and if you're also smoking, there'll be another fine, a larger fine of $100. So we're not saying it's okay, but we're also not saying that you'll be jailed and have a criminal arrest record for the rest of your life for it.
Now, will you be able to grow marijuana legally for personal use?
Nope.
Okay.
Any other questions? Yes, Councilmember Che.
Thank you, Mr. Chairman, and I want to thank Councilmember Bowser for raising the questions that she has raised, because this is not as simple and straightforward as you might think just at the outset, which is one of the reasons why I think we're proceeding here.
Is your microphone on?
Well, unless you shut you. Now he's frustrated. Mr. Chairman, but no, I was saying that I want to thank Councilmember Bowser for the questions that she's asked, because I think it does illustrate that this issue is not as simple as you might imagine. There are a number of related issues that arise with it, which is one of the reasons why I think we're proceeding, if you will, cautiously, which is to say not immediately taking up a bill for legalization, and instead looking at this from the perspective of decriminalization, because the ultimate goal here is not to allow simple possession of marijuana to destroy someone's life. And that's what's happening, and that is so disproportionate and so ill-conceived that what we're trying to do is address that. But there are a lot of related issues, and as you know, I'm prepared today, of course, to vote to send this to the council, and there may be other questions that are raised about it, but I look forward to this going forward, and I also look forward to a related bill that will ultimately come to the council to seal the records of people who have been convicted of simple possession of marijuana so that their lives can be restored in effect. And so I thank you, Mr. Chairman, for moving this, and I will be voting in favor.
Thank you very much. Any further discussion? There being no further discussion, all in favor say aye.
Aye.
Please note it's unanimous. And with, so the motion is passed. With no further business before the committee, but now I move the report. I move the report with leave for staff to make editorial, conforming and technical changes. Discussion. All in favor say aye.
Aye.
Motion passes. With no further business before the committee, the meeting is adjourned.